Sale, definition and ingredients under the Sale of Goods Act, 1930. Question: define the term sale. What are its ingredients? What are the differences between sale and agreement to sale? Before understanding the concept of sale, let us briefly look at its background. Till the year 1930, transactions relating to the sale and purchase of goods were governed by the Indian Contract Act, 1872. However, in 1930, Sections 76 to 123 of the Indian Contract Act were repealed, and a separate legislation was introduced known as the Sale of Goods Act, 1930. This act came into force on 1 July 1930. Later, with effect from 22 September 1963, the word Indian was removed from its title. Today, it is known simply as the Sale of Goods Act, 1930, and it extends to the whole of India. Let us now understand Section 5 of the Sale of Goods Act, 1930, Contract of Sale. How made? A contract of sale is formed through a simple legal process. First, there must be an offer, either to buy or to sell goods for a price. Second, this offer must be accepted by the other party. Only when an offer is accepted, a valid contract of sale comes into existence. Now, such a contract may take different forms. It may provide for immediate delivery of goods, or immediate payment of price, or even both. Alternatively, the contract may allow delivery or payment in installments. It may also specify that the delivery or payment, or both, will be postponed to a future date. Moving further, Section 5 also explains the mode of making a contract of sale. A contract of sale can be made in multiple ways. It may be in writing, or by word of mouth, or partly in writing and partly oral. Importantly, a contract can also be implied from the conduct of the parties. This means that even without express words, the behavior of the parties can create a valid contract. Ingredients of sale. First, there must be a seller and a buyer. Second, there must be some goods. Third, property in goods must be transferred. Fourth, there must be a price. Fifth, essential elements of a valid contract should be there. Let us now understand the first essential element of a contract of sale. There must be two distinct parties, a seller and a buyer. A seller is a person who sells or agrees to sell goods. On the other hand, a buyer is a person who buys or agrees to buy goods. It is important to note that both parties must be different persons, as one cannot buy from oneself. Thus, the existence of a seller and a buyer is the most basic requirement of a valid contract of sale. Let us now move to the second essential element of a contract of sale. There must be some goods. According to Section 2, Clause 7 of the Sale of Goods Act, 1930, goods means every kind of movable property, except actionable claims and money. This definition is quite wide and includes several types of movable property. For example, it includes stocks and shares. It also includes growing crops, grass, and things attached to land, provided that they are agreed to be severed before sale or under the contract of sale. In simple terms, anything that can be moved and transferred, except money and actionable claims, can be considered as goods. Types of goods. As per Section 6, for the purpose of sale, the goods are classified into three categories. First, existing goods, second, future goods, and third, contingent goods. The existing goods is also put into three categories. First, specific goods. Second, ascertained goods. Third, unascertained goods. According to Section 6, the subject matter of a contract of sale may be either existing goods or future goods. Existing goods are readily available with the seller, whereas future goods are those which are yet to be acquired or produced. Further, the law also recognizes situations where the seller's ability to acquire goods depends on a contingency which may or may not happen. In such cases, the contract is still valid, though subject to that uncertain event. Importantly, where a seller attempts to make a present sale of future goods, the law does not treat it as an actual sale. Instead, such a contract is considered only as an agreement to sell. Let us now understand the concept of existing goods under the Sale of Goods Act, 1930. Existing goods are those goods which are already owned or possessed by the seller at the time of the contract of sale. Existing goods may be classified into three categories: specific goods, ascertained goods, and unascertained goods. First, specific goods, as defined under Section 2(14). These are the goods which are clearly identified and agreed upon at the time the contract of sale is made. For example, a particular car, a specific ring, or a designated television set. Second, ascertained goods. These are goods which are identified after the contract is made from a larger bulk of unascertained goods. In other words, when a specific quantity is separated and earmarked from a larger stock for a particular contract, such goods are called ascertained goods. Third, unascertained goods. These are goods which are not specifically identified or agreed upon at the time of the contract. They usually form part of a larger stock or bulk, such as goods lying in lots or general inventory. Future goods, as defined under Section 2(6). Future goods are those goods which are yet to be manufactured, produced, or acquired by the seller after the contract of sale is made. Since these goods do not exist at the time of the contract, there can only be an agreement to sell and not an actual sale. This is because a person cannot sell goods which he does not yet possess. Now, moving to contingent goods, as provided under Section 6, subsection 2. Contingent goods are those goods, the acquisition of which by the seller depends upon the happening of a contingency which may or may not occur. In simple terms, the contract depends on an uncertain future event. Let us now understand the rules relating to perishing of goods under Sections 7 and 8 of the Sale of Goods Act, 1930. First, Section 7, Goods perishing before making of contract. Where there is a contract for the sale of specific goods, the contract becomes void if, at the time of making the contract, the goods have already perished or are so damaged that they no longer match the description in the contract. And importantly, this must be without the knowledge of the seller. In such a case, the contract is treated as if it never existed. Now, Section 8, Goods perishing after agreement to sell but before sale. Where there is an agreement to sell specific goods, and after the agreement is made, the goods perish or are damaged without any fault of either party. And this happens before the risk passes to the buyer. Then the agreement becomes void. Thus, in both cases, the law protects the parties when the subject matter of the contract no longer exists or loses its identity without their fault. Let us now understand the third essential element of a contract of sale. There must be a transfer of property in goods. According to Section 2, Clause 11, the term property means the general property in goods, and not merely a special property. General property refers to the ownership of the goods, whereas special property refers only to possession of the goods. In a contract of sale, what is important is the transfer of ownership, not just possession. Therefore, there must be either an actual transfer of ownership or an agreement to transfer ownership in the future. When the ownership is transferred immediately, it is called a sale. And when the transfer is to take place at a future time or subject to conditions, it is known as an agreement to sell. The fourth essential element of a contract of sale. There must be a price. According to Section 2, Clause 10, price means the money consideration for a sale of goods. This means that the consideration must always be in money form. If goods are exchanged for goods, it is not a sale, but a barter. Under Sections 9 and 10, the price may be determined in different ways. It may be fixed by the contract, or left to be fixed in a manner agreed upon, or it may be determined by the course of dealings between the parties. If the price is not expressly fixed, the buyer is required to pay a reasonable price depending on the circumstances of each case. Thus, the presence of money consideration is essential to constitute a valid contract of sale. The question is that, what are the various modes to determining price of goods which are the subject matter of a sale? As per Section 9, the price in a contract of sale may be fixed by the contract or may be left to be fixed in manner thereby agreed or may be determined by the course of dealing between the parties. where the price is not determined in accordance with the foregoing provisions, the buyer shall pay the seller a reasonable price. What is a reasonable price is a question of fact dependent on the circumstances of each particular case. That means there are three modes of determining the price as under. First, it may be fixed by the contract, or second, it may be left to be fixed in an agreed manner. Third, it may be determined by the course of dealing between the parties. Thus, the price need not necessarily be fixed at the time of sale. In other words, fixed price is not essentials of the contract of sale. Consequences of not determining the price in any of the mode, where the price is not determined in accordance with Section 9, 1. The buyer must pay seller a reasonable price. What is a reasonable price is a question of fact dependent on the circumstances of each particular case. It may be noted that a reasonable price need not be market price, where the price is to be fixed by third-party agreement to sell at valuation, as per the S. 10, 1, where there is an agreement to sell goods on the terms that the price is to be fixed by the valuation of a third party and such third party cannot or does not make such valuation, the agreement is thereby avoided, provided that, if the goods or any part thereof have been delivered to and appropriated by the buyer, he shall pay a reasonable price therefor. That means the agreement to sell of goods becomes void if the following two conditions are fulfilled. If such agreement provided that the price is to be fixed by the valuation of a third party, and such third party cannot or does not make such valuation, where the seller or buyer has prevented to third person for valuation. Section 10, subclause 2 says that, where such third party is prevented from making the valuation by the fault of the seller or buyer, the party not in fault may maintain a suit for damages against the party in fault. Let us now understand the fifth essential requirement of a contract of sale. In addition to all the elements discussed earlier, a contract of sale must also satisfy the essential elements of a valid contract as laid down under Section 10 of the Indian Contract Act, 1872. This is because a contract of sale is a special type of contract, and therefore all general principles of contract law are applicable to it. These essentials include free consent of the parties, competency to contract, lawful consideration, lawful object, and that the agreement must not be expressly declared void. If any of these elements are missing, the contract of sale will not be valid in the eyes of law. Thus, compliance with Section 10 of the Indian Contract Act is mandatory for a valid contract of sale.